12:05. Hopefully we'll get a few more people joining soon. So I'm Judge Sheldrick, Judge Emily Sheldrick, and I'm presenting along with Ben Shafton. If you don't know Ben, he's been practicing in Clark County for a number of decades. He is recently retired, but is still doing some stuff, including arbitrations. I asked him to join us because he is one of the more popularly chosen arbitrators with our mandatory arbitration. So he's going to give some information on what it's like to actually do mandatory arbitrations as an arbitrator. I'm going to start us off with some basics on how a Superior Court case kind of gets shifted over to arbitration. Can everyone hear me okay? If at all there's any questions, thanks, Josh. Put it in the chat, and hopefully we will have time. I'm sure we will for some conversation. So let me get started. Excuse me. Let me get started with a PowerPoint slide. So let me get that going. Just also one other quick reminder in the chat is the link for making sure you register for the CLE. So make sure to do that. Okay, so the basics. How does this get to arbitration? If you don't know already, there's an RCW that says that if you're only asking for money and the amount does not exceed $100,000, then it goes to mandatory arbitration. There are two ways the case gets referred to mandatory arbitration. One is through LCR 40C, and the statement of arbitrability has to be filed at least 10 court days before the scheduling conference. And then after that, with leave of the court. If the case is not subject to LCR 40C, then it's referred to mandatory arbitration at the time of the notice to set for trial. So that's how it kind of gets moving. Obviously, most cases are subject to LCR 40C that get referred to mandatory arbitration, personal injury, contract disputes, etc. So that's going to be the primary way it gets referred to arbitration. If you are interested in being an arbitrator, which I hope you are by joining the CLE, you do have to submit an application on the Superior Court website. It's under the main page for Clark County, and I'll put a link in the chat when I'm done. But you go to Civil tab, and then there's an arbitration subfolder, and that's where there's a link to the application form. You do have to be a member of the Washington State Bar in good standing with at least 5 years of experience, or you're a retired judge or commissioner. And you have to complete 3 credits of a CLE on professionalism and ethical considerations, and that's required by statute. Once you've submitted an application that confirms those, then it goes to the Superior Court judges and we vote on approving an application. And once you're approved, then you go on the master list, and the master list is within court administration. Both parties can ask for the full list, but typically the court gets a stipulation from the parties, or they provide a list of 7 names, and then each side nominates 3 arbitrators and strikes 3 arbitrators. If there's no one that's been nominated by both parties, then the court administration randomly appoints the arbitrator from those not stricken by either party. And I think this is where I was thinking of kind of handing it off to Ben. The only other point is just you have to accept confirmation that you are willing to be the arbitrator within 5 days. And then it's my understanding that the hearing has to be held within 75 days of appointment. And then the compensation is the same as a judge pro tem. It's currently $124.22 an hour, but that is going up in July. And that includes preparation and hearing time. So that's sort of the basics to get us rolling. Ben, I'll hand it off to you.
Okay. Can you guys hear me okay? If anybody can't hear me, send up a smoke signal or something, okay? All right. So first thing is, why should I be a mandatory arbitrator? Well, you should not do it for the money. That's very clear. It's right in front. It's right in front. It's about 125 bucks an hour, which is pretty good if you have absolutely no overhead. But most of us do, so it's not for the money. Basically, from my point of view, there are three reasons that you might want to be a mandatory arbitrator. First of all, you get to sit on the other side of the court, if you will. You're listening to people tell you stuff as opposed to telling people stuff. Now, what's the benefit of this? Well, first of all, you get to see other lawyers in action, and you get to see them from the perspective of being the audience. You're evaluating them as they do. And so basically, you get to see what works and what doesn't work, and you can apply that to your own practice. You can seek to emulate what's good and not to emulate what's not so good. Next, you get to see if you like being on that side, because maybe you aspire to be a judge someday. Well, if you like this kind of thing, then maybe that's a good move for you. And if you don't, well, okay, that's not a good move for you. And you also get to the third thing is you get to meet and evaluate and see your other your colleagues around town that you might not otherwise see. And sometimes these people can be you can be surprised by some of these people. For example, there's one member of the Superior Court bench right now who I knew when he was a lawyer. See, I've already given away it's a male, but I didn't really know him very well. And so he did a mandatory arbitration, and I was the arbitrator. And he really did a bang up job. I mean, he did really well in terms of his presentation, what he had to say and stuff. And so when he decided to be a judge, he asked me for his support. And I said, yep, you've got my support. And it's things like this that you wouldn't otherwise see. So those are the reasons to do it. Another reason to do it is to embellish your karma, which is very important. Now, if you're involved as a litigant in mandatory arbitration cases, that means that somebody else took the pittance of the pay to help you resolve your case. So now you can kind of pass it along by being a mandatory arbitrator to help somebody else resolve his case or her case. And you also get to help the judicial system function better. Now, we all have an interest in having a smoothly functioning judicial system, and it functions best when cases move quickly as possible and get resolved. What clients want is resolution among anything else, especially if they're the plaintiff in a lawsuit. And mandatory arbitration helps to get that done for cases that are not a godzillion dollars in value. Now, let's concentrate on that third one. But the goal is to get cases resolved, and we have to have a hearing within 75 days. Okay, well, how do you, as an arbitrator, get that done? Well, it's a problem because sometimes lawyers have kind of other things on their agenda, schedule, and maybe they don't want to do it. Or something that I see from time to time is that there's a case that got filed just before a personal injury case got filed, just before the statute of limitations was going to run. Somebody had to do something with this. So, well, I guess we got to file a lawsuit, but it's kind of on the back burner of that particular lawyer's caseload. Well, when I get an assignment, the first thing I do is to check for conflicts, to see if anybody in our firm knows any of the people involved in this. Typically, that's not the case, but it can happen. And then the next thing I do is I email the parties and I introduce myself. And I tell them a number of different things, which we'll get to. But the most important thing that I tell them is that I expect them to consult on a hearing date and get back to me as to hearing dates that they can do. And I ask them for 3, and I ask them to get back to me in 1 week. I tell them what my availability is in general terms, and then I tell them to get back to me. Now, why do I do this? Well, I'm taking charge of getting this case resolved. It's the arbitrator's responsibility to make sure the case gets resolved, and the best way to do that is to set the hearing. And it's really amazing when the arbitrator takes charge of getting the hearing set, because amazing things seem to happen when you do that. And what happens most often is, miraculously, the case settles. These are people who did their stipulated joint report to the court that said basically, okay, this is worth less than $100,000, and then the file goes into the file drawer. Well, now I'm making them think about the case. And it's amazing how many of these cases settle. I don't do that many hearings. Most of my cases get settled, and I think that this might have something to do with it.
What do you do if they don't get back to you, or they give you date beyond the 75?
Well, just so everybody else knows, Judge Sheldrick and I didn't rehearse that line before she asked this question. I didn't think she was going to ask me that, but I was really prepared to tell you exactly what happens, because there are a number of times when I don't hear from these people within a week. So what I do is I send out an email on about the 10th day, give people a little bit of leeway. And I say, we're having a conference by phone, and we're having it 1 week from today, and the plaintiff arranges for the conference call. That's what I do. Well, what happens if number one, there's no date and nobody sets up a conference call? Well, then the third email goes out. If I don't hear from you guys within 1 week of the date of this email, I'm setting the hearing at a date that's convenient for me. And if somebody doesn't like that date for some reason other than death or illness or, something really amazing, that's the date it's going to be. And I don't care if you have any conflicts on that day, because you didn't get back to me. And still nothing. This has happened. I set the hearing. There was one case that I remember. I hate war stories, but I got to tell you about this.
Now you have to tell us.
Yeah. Where I couldn't get the plaintiff's lawyer to respond to me. This is a personal injury case. Couldn't get the plaintiff's lawyer to respond. Could hardly get the defense lawyer to respond. But I couldn't get a conference call. I even emailed his assistant. Couldn't get a conference call. Couldn't get anything. Set the hearing. And I think 2 weeks after I set the hearing, I get an email from the defense lawyer telling me that the case is settled. So pushing is what tends to get the case resolved. And usually the cases do settle. So this is a good thing. Now, so far, we haven't covered one thing that's important, which is if you get the case, should you accept it? This is very important. In that first email, I ask the people to send me the complaint and the answer, so I have an idea what's going on in this case. But you can also get on to OnPoint, which if they don't give back to you, which sometimes they don't, you go to OnPoint and you can look and you can see the complaint and the answer. And this may give you a clue as to what this case is about. Now, you may not feel comfortable dealing with this case, the nature of the case. Well, so here's what I can tell you. If this is a personal injury case and you have never done any personal injury work, and you're going to be asked to give some kind of decision perhaps on non-economic damages, and you really don't have a clue about this, and you really feel uncomfortable, maybe you should refuse the assignment. If it's some contractual issue or statutory issue, you'll figure it out. Don't worry about that. You'll figure it out. But if you're really uncomfortable with the type of case that it is, get back to the people at court administration, say, I really can't deal with this. It's really not my wheelhouse. I don't feel comfortable. I don't feel comfortable. It's better that you do that than you render a decision where you're really not feeling good about the decision that you make. Okay. Now you've heard what a jerk an arbitrator may need to be in order to get the hearing settled or get the case set. Let's go in the other direction, because what you want in terms of the hearing is something that is easy and convenient for the people who are going to be participating in it. Now, my first email has several other things that I tell everybody. First of all, service of everything is electronic. Secondly, all communication with me is by email with a copy to the other side. Yes, I've had the experience as an arbitrator of one of the parties emailing me and not copying the other side. Not cool. So I figure that I have to let people know about this. Next, all hearings are by Zoom. Nobody has to show up anyplace, including me. I mean, I like to do these hearings at my house, which is where I am now. And nobody should have to go anywhere else. And everybody is responsible for getting their own witnesses lined up. And the plaintiff is responsible for setting up the Zoom conference. Now, there's a local rule. It's Rule 5.1, for those of you who want to get in and look at it, that says that all hearings for mandatory arbitration have to be held in Clark County. Now, that was a product of something that happened a number of years ago when a lot of Portland insurance defense lawyers decided that they wanted to be mandatory arbitrators in Clark County. For reasons that I'm sure we can all figure out if we thought for about 30 seconds. And they were making people come to their offices in Portland to do the arbitration. And this didn't go over well. Well, I haven't seen any revision to that, especially since Zoom, but that's okay, because Zoom hearings have been kind of recent. And as a suggestion, the judges might want to say that that a Zoom hearing is okay, is deemed to be done in Clark County. I've also seen that there are still some arbitrators from out of Clark County And if the judges want to make sure that all the arbitrators are within Clark County, which is something that they can consider, they could say, the hearing is in Clark County if the arbitrator is in Clark County. I say that because what you're going to find is, and what I'm increasingly finding, is that there are a lot of out-of-county attorneys who are participating in mandatory arbitrations. As a matter of fact, I'd say in the last 3 or 4 I've done, both attorneys were outside of Clark County, in Portland, Seattle, just various different places.
I think that's a really good point. I know it's come up as a question, the local rule. We obviously have our local rulemaking process that we've passed the deadline for this year. But I think that what you're suggesting is a good one. I don't know, Mark, you unmuted yourself. Did you have anything you wanted to add on that point? Or any question? Okay,
Nope, my apologies. That was an error.
all right. Um,
Okay,
I think it's a good suggestion though, and a good point. I don't think the local rule reflects practice.
okay. Now, the next thing that I tell everybody in an email is courtroom attire is optional in this arbitration hearing. Now, I don't like to get a coat and tie on, and I don't see why anybody else should. And you know, you'll see how this works as we go along here, but courtroom attire is optional. I'm trying to make it easy for,
Maybe some attire though.
well, some attire. I mean, you know,
You'd be surprised what we see in court.
okay,
You Zoom.
all right. I also tell the people that I want their pre-hearing statement of proof, briefs, and all documents by 2 weeks before the hearing, in accordance with the mandatory rule that says you got to submit that stuff within 2 weeks. And I want it by email to me, and I'm going to review it. And what I say to the people is, I'm going to read every word. Now, there's a reason for that. And the reason is that I want to be prepared before that hearing so I know what this case is about. And I really do read every word. And because I'm an old guy and I don't function really well sometimes with a bunch of PDFs, I'll print it out and I'll highlight it and stuff like that, so I can see I can see the good points. It's important that the parties know that I'm going to be prepared, so they don't have to feel that they have to spoon feed me all through the hearing. Now, am I going to get everything 100% before that hearing by reading everything? No, I'm not. That's why we have the hearing, so that people can flesh it out. Now, there's a practice that's going on that can help in figuring that out, figuring out what's going to happen. Instead of the pre-hearing statement of proof being just the minimum, these are my witnesses, these are my documents, here you go. The good lawyers are including a short brief about what the case is about, so that and that helps immeasurably in terms of getting the lay of the land in a general sense, so you can start drilling down on all this stuff. But if somebody sends me 150 pages of chiropractic notes, yep, I'm going to go through every one. May not help me much, but I'm going to do it. And last, but certainly not least, I tell everybody in that first email, we are going to call each other by our first names. And my name is Ben. Now, why do I do that? It promotes collegiality, especially when you're dealing with lawyers in different places and they probably don't know each other. I found during my checkered career that if people are calling each other by their first names, that they're going to get along better. And if people get along better, all aspects of litigation are going to go more smoothly. So that's what I insist on. Sometimes I get emails, especially from legal assistants, back saying, "Dear Mr. Shafton," or "Dear Arbitrator Shafton," I have to come back and say, "No, wait a minute. We have a rule here. If you want to talk to Mr. Shafton, that's my father. I'll see if I can get him on the line for you. But my name is Ben. So please call me Ben." And then I go, "Oh, sorry. Thank you, Ben." And then it's fine. So just now, that may not work for you. It works for me. Okay. Now we've gotten to the hearing. The case hasn't settled, and you have to act in the role of an arbitrator. Well, basically, an arbitration is a trial with relaxed rules. That's basically what it is. You've all read the rules. You know it's presumed admissible. Well, what do you want from a judge? The arbitrator is a judge. What do you want from a judge? Well, when I was doing this stuff, I really wanted two things from a judge. I wanted the judge to be courteous, and I wanted the judge to be prepared. Well, that's what you got to do. You got to be courteous to everybody, and you got to be prepared. You got to read the stuff to be prepared so that you know what you're doing. Oh, by the way, I almost forgot. Sometimes people will have objections to documents. Well, what I tell people in the opening email is, if you have objections to the documents, email me immediately, and I won't look at those. I won't look at those until the hearing comes and we can argue about it. Okay. But going back now.
Should I share the slides that talk about the arbitrator authority? Do you want to
Sure.
do that really quick?
Yes.
Okay.
Yes.
So let me share this screen really quick. See if I can find it. Hold on a second. Here we go.
Okay.
There you go.
Now, basically, if you look at this, you'll see that the arbitrator is deciding just about everything that there is to be decided. But there's one critical thing that the arbitrator is not doing. And that is that the arbitrator does not rule or consider motions for summary judgment. You make your summary judgment, the summary judgment motions go to the judge. And I've had people, one time that somebody wanted to give me a motion for summary judgment, and I had to say, no, you give that to the judge. Now, you have to be courteous, you have to be prepared. What I try to do, especially, oh, yes, and here's discovery. Sometimes the people will come to me and say, we don't want to schedule a hearing because we still have discovery to do. Now, it seems to, now I saw this when cases were not moving because of COVID. I haven't seen it recently, but it can happen. And so if somebody emails me that, I say, okay, we're having a phone conference and we're going to talk about it. I'm going to let, I always err on the side of letting people do the discovery they want to do, because I'm here to resolve the case. I'm not here to just make a decision and be all tightened up about it. Because you see, if somebody doesn't like my decision, that person can appeal. And if that person appeals because he or she didn't get the discovery they wanted, then the whole thing has not been a good exercise. So I'm going to err on the side of authorizing discovery unless it's something, like really, really, really um, uh, uh, amazing. For example, if somebody wants to do a public records request from 5 or 6 or 7 different agencies for a case that has a value of $7,500 and wants to, go and continue the case for 3 months to do that, I'm not going to be real receptive to that. So we always want to keep it in tune with what the case is about. So at the hearing, I'm trying to be businesslike, but I'm trying to keep it light enough so that people understand that this is civil litigation as opposed to the future of the planet. There's one thing that I do for the parties. I begin this by telling the parties how I was chosen. And typically what I say is something like this. I say I was on a list of 7, and each got to get rid of 3. And so I was the one left over. So I'm the guy that the 2 lawyers disliked the least. That usually gets a laugh from the parties, which is kind of what they need at that point because they're kind of freaked out because it's their case. And so that kind of helps keep things light, or at least a little lighter than it needs to be. Now, most of the hearings that I see last for maybe half to 3/4 a day. Some will last less. But I don't think I've ever had one that lasted more than a day. I give parties as much time as they want to argue. I tell people you don't need to make an opening statement because I've read all this stuff. And typically people respect that, and they try to make their presentations brief and to the point. Haven't had anybody really yammer on and on and on and on about that. So I don't know what I would do if somebody did something like that. Also at the hearing, if there's a real live evidentiary objection, I'm going to err on the side of admitting the evidence and then giving it the consideration I think it deserves. Which means if it's really out to lunch, I'm not going to consider it. Once again, I don't want somebody who's going to appeal on the basis that some piece of evidence didn't come in. Now, let's talk about the decision. Under the rule, the arbitrator has 2 weeks to get the decision out. I try to get it out sooner than that. The reason that I try to get out sooner is that I want to get it out when it's fresh in my mind. And if I delay, it's not going to be fresh anymore. And so I try to get it out as soon as possible. The materials showed the mandatory arbitration form, which is basically I award a certain amount of money, and that's it. No explanation, no nothing. I always send a letter with an analysis. Why I ruled the way I did. This is so people will know, there it is on the screen. And as you can see, there's not much there. And here, could you scroll there? There you go. The arbitrator's decision is attached here too. You see that part? Go up. There you go. It's right there at the top. The arbitrator's decision is attached here too. I always put no, because this decision gets filed. Well, I don't want this to be filed. I want this for the lawyers, so the lawyers can understand what I was doing, and they can use it to govern their decision on whether or not to appeal. For example, in a personal injury case, and oh, by the way, the cases that I see, I'd say the majority of them are personal injury cases. The most important thing in a personal injury case, I learned from a very experienced lawyer who is even older than I am. The most important thing is how the plaintiff presents himself or herself, and whether the plaintiff is a credible person. And and that's what I always start with. Now, you see, this is very important for an insurance company that's trying to make a decision on whether or not they like the award or they don't like the award, and whether or not they want to appeal. What the insurance company adjuster has gotten so far is something from the defense lawyer giving his or her view of whether the plaintiff presents well or is credible. Well, I'm a neutral party. I'm just a guy who's seeing this person for the first time, and I really don't have any particular axe to grind in any way, shape, or form. So I always tell them that, so they will know. I'm always going to tell people how I reached my decision, so that they can see what it is, for two reasons. Number one, as I said, they can figure out whether they, whether or not I've lost my mind and they really need to appeal. Or secondly, I may have come up with something that they didn't think about, and like, oh, and that helps them understand what their case is about more than they did before, hopefully, and not appeal for that reason. There have been situations, one in particular comes to mind, where I had to do my own research on a point, and neither of the parties had brought up this particular point, but it was critical. One of the things that I did when I saw that is that I sent an email to both parties saying, here's the case I'm looking at, and here's the point that I'm concerned with. And neither of you guys told me anything about this. So I'm going to give you a week to tell me whatever you want to tell me about this. Just send me an email, tell me what you think. You don't have to write a pleading or anything. Just email me what you want. So that way, I'm not coming up with something that nobody had the chance to address. I think that's important. Now, one of the things that that as an arbitrator that you may be frustrated by is sometimes parties mail it in. They're just really not prepared, or they're just not really doing much. There's some insurance defense firms, when I ask them, okay, well, what do you think this is worth? I won't tell you. And in the cross-examination of the plaintiff, they don't do any. And so, and I don't know what to do about that, except that I have to make a decision on what I'm presented with. Sometimes people leave out critical evidence. or evidence at least that I think is critical. For example, I had a collection case, wasn't a large collection case, but it was a collection case where the plaintiff collection agency said, the defendant owes this much. The defendant says, I paid a bunch of that. Well, you would expect that the collection agency would then give me their entire business record about what they got and what they didn't get. Well, they didn't give me that. And so I've got to make a ruling based upon what I get. Now, once I get the decision out, I email the decision to the parties. If this is an attorney's fees case, which sometimes it is, not in personal injury cases, but in other cases it is, before I make my decision, I tell both attorneys that I want what amounts to an attorney's fees affidavit from each of them before I make my decision. So I'm not telling whose favor I'm going to rule in. I just want it from both of them. Typically what that's going to be is what the rate is and how many hours they spend. And I will incorporate that. Now, if you look at the rule, you'll see that after I do my first decision, they can come back and then we have a procedure for the costs and the attorney's fees. I like to do that. I ask them for a cost bill in all cases, attorney's fees affidavit if it's an attorney's fees case, so I can wrap that into my initial decision. I want to try to get it out as soon as I can, within 14 days. And then I see that the decision is filed. And I also see that the decision is mailed, because it's the mailing of the decision that triggers the 14 days. So I've got to, the 20 days to appeal. And I got to see that that's filed as well. And once there, I send a copy of the decision. That's that one-page thing to the court administrator, and send in the affidavit of how much time I spent. And then I'm done. Sometimes I go to On Point myself and see if somebody, or Odyssey or something, and see if anybody's appealed. Most of the time they don't. I don't know why, but they don't. Okay, that's my rant. If anybody has any questions, do you think there are questions on chat, Judge?
No, there aren't, but please do chime in with any questions. I will just note, I agree with what Ben said about attaching, not including the written decision with the award, since it's only the award that if it gets down to a judgment, that's what the court enters, is a judgment based on an award, not on a written decision. So if it's a trial de novo, the decision doesn't really matter. It's the award that matters if there's no trial de novo. So I think that's a good practice point for all of you. In the materials that Lisa sent out, you'll see all the forms that are from court administration. They might get updated on occasion, so these may not be like the forever forms, but I wanted you to at least have a complete set of what to expect if you're selected as an arbitrator in the future, or you apply, which I hope you will. We do want more arbitrators. We have a sizable list, but it does include a number of attorneys that we are regularly hearing are retiring. So we are encouraging more people to apply, so spread the word. I don't know if there's any other questions that anybody has before we sign off. And let me just double check. I was going to show a couple of forms. Let me share my screen so you can all see a couple of the forms. Um, this is the arbitrator compensation form. So it's similar to your billing practices that you already probably do. And then here's the application. I put the link in the chat. So there's several pages about some background information to help the judges when they review your application. Anyone?
I have a question.
Hi, Leslie. Yes.
Hi, thank you. First of all, Ben, thank you. That was very informative and helpful, your experience in sharing that with us. The one question I had, have you ever had a situation where you had a conflict with any of the parties, meaning a conflict of interest such that you couldn't be the arbitrator? And if so, how did you handle that?
You know, I got to tell you, nothing comes to mind, but I'm sure it's happened. And what I what I hope I did was well, the first thing that any arbitrator has to do is to check for conflicts. And so also, if the attorneys who are representing the parties are on the ball, they'll let you know if there's a conflict. Okay. And in that and if if an attorney says, parenthetically, if an attorney says, Ben, I think you have a conflict, fine, because I'm not going to argue with anybody about whether there's a conflict, and then somebody thinks they have to take an appeal because that jerk of an arbitrator wouldn't get out of the case. So what I do in that point, if I figure out there's a conflict, or what I hope I would have done, is I immediately email the court administrator and say, I can't accept this. Typically, the email that you get from court administration saying that you've been selected will say, if let us know within 5 days if you can accept this assignment. So they want to hear back. So that's what you do. In the situation that I described where a lawyer says, Ben, I think you have a conflict. I would copy the two lawyers on my email to court administration, so they know what was going on.
Thank you. That makes sense. And I guess I have one more question.
Shoot.
Have you had a situation where you gave your decision, your award, and the parties came back to you with questions?
Can't remember one.
Okay.
I guess that's maybe because I write too much, and so all the and they just have, let's get rid of that guy. I don't want to talk to him anymore.
Thank you. I appreciate it.
If they did have questions, or more importantly, if they thought I'd missed something, and there's something in the rules that allows for reconsideration if somebody thinks the arbitrator has really missed something. And I'd be receptive to that if it happened. If somebody wants to argue with me again, I'm not interested in that. But if they think I made a mistake, cool, let's see if we can get it right.
Thank you.
Anyone else? I guess the only other question I had is, Ben, it sounded like you've had this before, but have you had pro se parties? And if so, have you handled it any differently?
Um, I don't remember having an arbitration. Oh, no, I had one arbitration with a pro se party. And the problem that I had with him is that it was, as I remember, it was a collection case and it was a male person. That's why I say he. And um, he was trying hard, but he just didn't get the procedural context. And he was there. He would send me like weird, well, weird is the wrong word. Emails of a person who just wasn't getting it. And finally, what happened is that the attorney representing the collector made a summary judgment motion that was granted, and I wound up not hearing the I wound up not hearing the arbitration at all. That's the only one I can remember.
Right. Every once in a while, I'll see one come through to mandatory arbitration that has a pro se party. I will say that in general, it seems like there's been an uptick in pro se litigants on the civil side from what I've seen. So I wouldn't be surprised if there's occasionally more pro se litigants with mandatory arbitration as well. Any other questions? Well, I think it's almost 1, so I think we're pretty much on the dot. Any final thoughts, Ben, before we conclude us?
Oh no. I've yammered on long enough.
Well, I thought it was super helpful. I'm glad we recorded this for future individuals that might want to think about being an arbitrator. Again, take a look at the materials. We also included the mandatory arbitration rules that Ben referenced, only the local rules. There are obviously state rules as well. Jim, is there anything you wanted to ask or?
I just wanted to say, first of all, thank you, Judge. Thank you, Ben. It's good to see you, Ben. I miss you. That's all.
Well, we
Thanks,
don't get
Jim.
to see you, but we're glad to hear your voice. All right. Well, thanks everyone. Have a great rest of your day and check out the materials and don't forget to do your registration on the link. All right. Thanks so much, everyone. Bye-bye.